Welcome back to the Nationalist Show. I'm your host and analyst, Kennedy Abongo. Our topic for today is why the Supreme Court may nullify the results. Before I proceed with that analysis, first of all, let me just thank our subscribers for yesterday. Our new subscribers, you are welcome to this show. I want to particularly thank our subscriber number 78 for your kind words. Those words encourage us and tell us that indeed we are heading in the right direction. Thank you very much. And then I would just still urge you, please, our subscribers, share our videos because you own this thing. Share our videos so that we may reach more people out there, so they see how objective to approach these issues that are rising in our country today. On to our topic of the day. Why do I think the Supreme Court may nullify the results? This analysis requires us to go back to the legal framework, particularly the Election Act, Section 83 of the Election Act. What does it provide? It provides that no election shall be declared to be void by reason of non-compliance with any written law. I need you to be very careful as I read. By reason of non-compliance with any written law to that election, if it appears that the election was conducted in accordance with the principles laid down in the Constitution and in that particular written law, or that the non-compliance did not affect the results. Two things come out. If you're keen enough, you will know that two things come out. Number one, it's that elections can be nullified where non-compliance with the written law to that election affect the result. You can interpret it the other way around, that non-compliance with that particular written law may not lead to nullification of results if it does not affect the results. What does that particular one mean? It means that in addition to considering the issue of non-compliance, the court will also direct itself to the question of numbers. That is the first one. Then the second one is that the election can be nullified when it does not comply with the principles laid down in the Constitution. From that reading alone, you'd realize that it does not now relate to the issue of numbers. It is directly on the Constitution. Did the commissions, did IEBC in conducting the presidential election conform with the principles laid down in the Constitution without going to the numbers? That is the first critical thing that you have to know, that in that particular one, the court does not consider numbers. So the second part is what led to the nullification of the 2017 presidential election. It does not go to numbers. I want to repeat for your understanding. So look at how the judges themselves were asking this question. And my analysis is really based on what questions they were asking. Justice Wanjala, for instance, was concerned about the role of the 6 commissioners. What were their roles in this election? Especially asking, what were the commissioners oversighting? If they were given roles, that is not the role that they are supposed to do under the Constitution, which is to oversight the electoral process. What were they then oversighting? They were not allowed to see the results. They were required to adopt those results. What then were they oversighting? Why were they given roles other than that which the Constitution mandates them to do in such circumstance? Number 2, Justice Mwilu also posed the same question, pricked her mind indeed. She wanted to know the role of those 6 commissioners once again, and the role particularly of the Secretariat. Why was the Secretariat, particularly the CEO, involved in that process in a very higher level than the commissioners? So that was a question that she wanted to know. She even went ahead and quoted the 2017 decision, noting that even though numbers were important, other factors. You see, so that is very pointed. That is very pointed, what she was intending to. She's removing you or asking the respondent that, okay, numbers are important, but you see, we have a constitution also. So these are the factors. She wanted to know how they are going to deal with them. Then Koome J, again, coming hard, concerned about the commissioners not doing what she termed as their core business, as stated in the Constitution, having them in other roles other than the ones stated for them in the Constitution. And she posed this question, that when these things started happening, and when the chair realized that there was lack of consensus amongst themselves, him and the commissioners, on the 4 commissioners on the one hand, and him on the other with the other 2 commissioners, why didn't he come out and address the nation on that specific issue? That we have the results, but now this particular section of the commission do not agree with this. Why couldn't he address? And in fact, she used very specific words. In the spirit of accountability and transparency. Those are core principles in the Constitution, in the conduct of presidential election or any other election for that matter. Justice Ouko, again, coming very hard and asked a specific question, how many votes constituted stray ballots? That was asked, how many votes constituted? She wanted to know the specific number so that he can address himself to the number of the discrepancy at issue, because these people are raising specific discrepancy, and the commissioners, the IEBC lawyers had indicated to court that that can be explained through stray ballots. So he asked a specific question, how many stray ballots were there, so that it could help him reach a proper decision. That answer was not given by a Mahat counsel as to how many votes were stray to help the judge reach that decision. Again, on the issue of resolution preceding the Chebukati's self-appointment as the national or the presidential returning officer, that again, it came out clear that they did not have an answer to that, and that relates to how the commission should work as provided in the Constitution. They should work as a unit. Work as a unit. That is the intention of the Constitution. So working as a unit, if you look at the history of the country, and CJ Koome also noted this, not really CJ Koome, Justice Njoki Ndung'u also noted this, that the reason why we formed a commission of this nature is so that the power vested in one person is diluted and spread. So you see Njoki Ndung'u, Justice Ouko, CJ Koome, DCJ, and Justice Wanjala, all of them are now just revolving around the constitution or factors that relate specifically to the Constitution. In my view, I therefore certain that these 5 justices may decide that the elections was not conducted as per the Constitution. And if they hold so, that the election was not conducted as per the Constitution, there is no way they are going to go to the numbers. That is my view. If they decide so, then they are not going to consider the numbers. There are let me say, the other 2 judges. It was very difficult for me to ascertain where, for instance, Justice Ibrahim would rule, but because his questions were not really pointed in one way or another. So his judgment will probably surprise me. And again, with Justice Lenaola, I think Lenaola would probably rule in favor of the respondents, for the reason that he was so much concerned with technology, and the report really excited him. If you could see, the report really excited him, and he tried to have that explained further in detail, especially when Murgor challenged Murgor with respect to his report. He wanted to know more. So that is our view on why the Supreme Court may nullify the results. It could be 5-2. We may be wrong, but in review of the questions that were asked, that is what we think the Supreme Court, that is why we think the Supreme Court will or may nullify the results. In our next video, which I welcome you again to watch, we will be discussing politics now, why Ruto may win the elections after nullification. Thank you very much for watching and welcome once again.